And the chair calls Jim Bates, who's with the Funeral Consumers Alliance and is testifying against the bill. Tell us who you are, who you represent, and your position on the bill, please.
Okay, my name is Jim Bates. I'm a director with the Funeral Consumers Alliance. We're a national, state, and local advocacy group, nonprofit group, and we are against this bill. I think y'all are catching on to what's going on here. We're seeing this as industry protectionism. There's some things in here that we agree that the industry does need, some parts in here. We agree with that. The trouble with it, we do have some language, just 2 words in 2 different places could significantly change the impact that this bill can have for consumers and leave industry still with the things that they're wanting in this bill. Specifically, those 2 places is on Section 3, page 2, line 19, where the word injure has been removed. It's got deceive and defraud, which is an action that the person, the funeral director, is taking. Okay, and leaving that alone, that puts the burden on the consumer to prove what was going on in the funeral director's mind. When you take out injure, you leave nothing, no base for the consumer to stand on. So we want that word injure put back in there. Then on page 4, well, it starts on page 3 about charging the funeral director in charge. And it rocks along there. What this is several paragraphs, effectively what we feel like is putting a lot of barriers to charging a funeral director in charge over what the licensed funeral directors do. And there are times when the funeral director, we feel, the consumers feel that the funeral director in charge should not be held responsible for what a licensed funeral director does. We understand that. Employees do bad things. The funeral director in charge should not be held responsible. We've had several cases that have come to the commission where this has occurred, and we suspect this is why this is being brought up to help shield them. On page 4, line 1, if that one word shall consider can be changed to the word may consider, we feel like this is a fair change in the language. What that would allow the commission to do, the funeral commission to do, was if they feel like the funeral director in charge had a lot of complicity or activity, responsibility for the licensed funeral director, then they can use this, then they can ignore this test and charge the funeral director in charge. If the funeral director in charge, if the commission feels like they were not involved, that they had a rogue employee or whatever, they could use this to shield the funeral director in charge. So that's what we're saying. In essence, the way it's written now, it puts so much barriers to holding the funeral director in charge responsible, and to put it in agricultural terms, we feel like it would be the equivalent of saying the principal is not responsible for what his licensed teachers do, or the police chief would not be responsible for what her officers do. We feel that it's like that. So those 2 words we offer up to change that. I think we can get a balanced approach with this.
Mr. Chairman, quick.
Yes.
Is a funeral director be both, obviously is a real person, but can it be a corporation as well?
No. A funeral director is a licensed profession.
Okay. So, but if you had a corporation and they hired the funeral director, if the funeral director themselves could be liable for the people who work below them, can't then the corporation be liable for the funeral director's decision?
Well, as I understand, the corporation cannot be held liable. The funeral director in charge can be regulated, and the funeral director themselves. I think they would have to go to civil court or something to go after the corporation.
Okay.
Not dead sure. Pardon me.
Just curious.
Yes, sir.
Thanks.
All right.
Are there other questions or comments? Mr. Bates, were you involved in the drafting and the deliberations of this, quote, cleanup bill?
No, sir. Unfortunately, in most cases, in most of the bills we work, there's a lot of cooperation with us in industry and the regulatory commission. There was phone conversations and email with industry over the past 4 months. The first time we all met together face-to-face was this morning at 9 o'clock in the cafeteria here at the Capitol.
Had you seen a draft of the bill either as filed or the substitute before this morning?
Yes, I'd seen that back in January when the bill came out, and then the substitute a couple of weeks ago. And that's when I began to act on it and try to get discussion on it.
Okay. Are there any other questions or comments? Thank you, sir.
You're welcome. Thank you.
Gary Schaefer.